Yes, great. I love that. Okay, guys, we're going to get started. Hi, welcome to our second to last installation of Ethics at Noon Talks. We will have one more talk this semester in 2 weeks by Jason DeCruz, probably on something about revenge. So please look out for any advertisement. And today we have the honor of having Allison.
Just Allison.
Okay, Allison to give us a talk on accessory liability in private law.
Wow, thanks so much for that introduction. Thank you so much for coming to my talk. And yes, I'm Allison, not a doctor. I'm just a doctoral student. And I'm in the SJD program here at the University of Toronto in the Faculty of Law. And I'm really excited to talk to you today about my project developing kind of a more general theory or kind of a theoretical justification for accessory liability in private law. So this is the first step of my doctoral project. So at this point in the project, I'm really just focused on looking at kind of existing approaches to the question of why we have accessory liability in private law, or drawing on existing approaches to kind of set the stage or kind of pave the way for me to develop my own theory in later stages of the project. So I actually want to start with just what I mean by private law. So when I'm talking about private law, I'm talking about the system of legal norms that governs relationships between individual people. So in a litigation context, this looks like a plaintiff suing an individual defendant, and the court giving a remedy to that plaintiff provided by the defendant. So why would a court do this in a private lawsuit? So I take the position that the only reason why we do this in private law is because the defendant had a duty to the plaintiff and they breached it. So that's really my starting point for my project, is that private law is about what we would call corrective justice. So the reason why a court is giving a remedy in a private lawsuit is to correct the injustice caused by the defendant's breach of duty. And so what do I mean by accessory liability? So I'm taking a really broad view of accessory liability at this point. There's no stable definition of accessory liability or universal definition of accessory liability, or private law for that matter. But just as kind of a starting point for understanding this type of case, I'm defining accessory liability as any type of liability where the defendant's liability is conditional on completion of some sort of primary wrong. So we're only holding an accessory liable if someone else has done something else that is a breach of their own legal duty. So you can see from this diagram, we have the accessory who has participated or become involved with some kind of primary wrong, and that is necessary for the accessory to be held liable to the plaintiff in a private lawsuit. So we're obviously focusing on accessory liability in the private law context, but I'm also pointing out that accessory liability is not just a term used in the private law context. It's actually most often used in the criminal law context when we're talking about aiding and abetting. So there's a couple kind of key differences that I want to point out at this point, just because this has been a point of tension in the literature before. So in criminal law, when we're talking about accessory liability, we're talking about a particular section of the criminal code that allows someone who assists with a crime or encourages a crime to be held liable for that crime. So if you drive someone to the site of a homicide, then you are also held or you're found guilty for homicide. Whereas in the private law context, I'm using a much broader, more fluid kind of concept, and I'm not assuming that the accessory is being held liable for the exact same wrong as the primary wrongdoer. I'm keeping an open mind to the idea that they might be or should be held liable for distinct wrongs, even if those wrongs are connected in some important way. And so what kind of thing am I talking about? So I want to talk about kind of a key case that we rely on in private law to illustrate this kind of situation. So this is a case called Lumley and Guy, and this established the tort of inducing breach of contract. So in this case, we have an opera manager, Mr. Lumley, running an opera house, who hires a dramatic artiste, as the case refers to her, to come sing at his opera house for a period of 3 months. So this seems great, but unfortunately, Mr. Guy, who is the manager at a competing opera house, also wants Miss Joanna Wagner to come sing at his opera house instead. So he offers her more money and says, come sing for me instead of Mr. Lumley. And that's what she does. She does that. So the court's not that impressed with this, though. And the court actually does hold Mr. Guy liable to Mr. Lumley for procuring this wrong. And so this case gave rise to the tort of inducing breach of contract, which has been well established in subsequent cases. So just to kind of set out kind of what the elements are for this kind of more well-established tort now. So we need to have a valid contract. The person who's actually a party to the contract actually needs to breach the contract. And then we also have some additional requirements. So the defendant actually has to know about the contract, and has to have actually intended that their contract would cause the breach in some way or contribute to the breach in some way. And the plaintiff actually has to suffer real damage because of that breach of contract. So if the plaintiff is no better or worse off as a result of the breach, then there's no tort of inducing breach of contract here. I also want to point out kind of another contentious point with respect to accessory liability in private law, and that is its relationship to joint liability for torts. So we have, the tort of inducing breach of contract, but we also have this weird tension where if we want to hold someone liable for inducing or assisting with a tort, then there's this additional requirement of a common design. So the parties having some kind of plan to act together. And so some people think that accessory liability is just a part of joint liability. Some people think it's separate. So I do just want to touch on that at this point, because it's a theme that will be kind of seen throughout the presentation. And I just wanted to point out that at least in Canada, there's 3 kind of different ways that parties can be held jointly liable for the same thing. So that's what I was talking about: concerted action, common design, joint action. I think they're all kind of interchangeable concepts. There's also agency relationships. So, one agent is acting on behalf of their principal, and vicarious liability, which is where an employee commits some kind of private wrong and then the employer is held liable. So vicarious liability, just about employment relationships. So kind of turning to my project. So, why do we even want a theory of accessory liability? Can we even have theories of legal principles and rules? What are we actually doing here? So the starting point for me is that we ought to have justifications for court orders. Courts are, they're coercive public institutions. So if a court orders you to do something, then they've intervened in your life. You have to do it. And courts should only be interfering in people's lives, granting these coercive orders against defendants for a really good reason. And that good reason should be able to be understood by everyone. And that's just a feature of our particular legal system. And so that brings us to what I think is kind of a problem with accessory liability, at least in the private law context. So we have all these kind of doctrinal problems, inconsistency between doctrines, a little bit unclear why we have rules we have or what those rules exactly are. But to me, this points to a deeper problem with us not really understanding the justification for accessory liability and not really understanding how accessory liability doctrines, which hold one person liable for their participation in a different wrong, kind of fits within our understanding of private law as really just being about rights and duties arising between particular legal relationships between 2 people. So to start kind of this exploration of this problem of why we have accessory liability, I am going to be talking about 3 possible answers to this question. So why do we have accessory liability? People have kind of given a few different answers, and these are 3 of them that we're going to be talking about in more detail. So the first one is just saying, well, we have accessory liability because we just treat the accessory as basically having done the primary wrong in some way. Alternatively, some people say, oh, it's a complete answer to have accessory liability because it's interfering with the plaintiff's right, and the plaintiff's primary right, the right that they have against that primary wrongdoer, is something that is really important to protect. And then third, kind of an answer that looks at both of these and says maybe that maybe these, both have important things to say about accessory liability, but we ultimately need a deeper justification, kind of grounded in the functioning of the legal system as a whole. Why is this, particularly a private legal wrong instead of just something that maybe we think is a bit distasteful? So I first want to turn to this idea of attribution, which is something that you do find in the literature as kind of set out as a justification for accessory liability, at least for some wrongs that we kind of characterize as accessorial. So in this case, we are either saying we're holding the accessory liable because we're treating them as legally responsible for the primary wrong, or we're actually saying we're going to pretend like the accessory did the thing that the primary wrongdoer did. So we'll, whatever this kind of, however attribution is functioning in accessory liability, if it is, I'll just remind us that we still need that breach of duty. So to hold someone legally responsible in private law, they need to have their own legal duty, and we need to at least treat them like they've breached that duty. And I think that the kind of connection between this idea of legal responsibility and legal duties is that legal duties are really just describing what we're responsible for. So when I'm kind of talking about legal duties and legal responsibility, that's the kind of connection that I'm envisioning. And we see that kind of played out in this case called Paul's graph. In this case, the court ended up holding that there was just no duty of care for towards people where it's not reasonably foreseeable that you would harm them. So this case just kind of stands for the proposition that we are only held liable when we actually have a legal duty towards the plaintiff. So again, I'm kind of starting with this when I'm exploring this idea of attribution. So we, like I said, so we need to have legal responsibility in order to impose liability. We don't just impose liability for no reason. So what are the different ways that we can hold a defendant legally responsible for something? So most straightforward case, you have a legal duty, you do something to breach it, you're held legally responsible for it. If I punch someone, I have a duty not to apply non-consensual physical force to other people. It was my arm, straightforward case. We generally don't have a problem with that. We also have these cases of joint liability that I was talking about. Either there's some kind of special legal relationship that justifies holding someone responsible for something that they didn't actually do, or also, like I was talking about with joint liability, there's some kind of group action going on that can serve as kind of the basis for this. So when we're holding someone liable for something that they didn't actually do, how exactly are we doing that? So I see 3 different options. The first option is by pretending like someone did something that they didn't do for a reason. We don't do any pretending, we find some other reason. Or what I think is the most promising in the accessory liability context, saying that someone did something wrongful and they're responsible for the consequences of that action. So just treating it as more of a consequence relationship. So I'm just going to talk about each of these in a little bit more detail. So this is for this option is where we directly attribute the action of someone to someone else. So if person X does something really straightforward, the law says person X did that thing, holds person X legally responsible, straightforward case. If we're looking at person Y, in this case, this is really where the magic happens. So we basically just pretend like person Y did it instead of person X. So I mean, I think that this might be a bit of a legal fiction, though happy to chat about that more. And this is the way that we get to person Y being legally responsible. And this might be what is happening in joint liability for torts. I'm certainly not suggesting that it's a fiction that people can act together, but the law actually goes a little bit further than that. It doesn't just say, oh, we all kind of do things together and that contributes to one joint action. The law goes further and says, you all did this joint action together, so we can pretend like each of you actually did all of the other actions of all the other people. So if we're making a cake together, I crack the eggs, you sift the flour, we all do things to make a cake all together. At the end, we're all eating the cake, and I say, oh, like we made a really good cake, and we all agree. And then I weirdly decide to start listing my own contributions, and you're all like, okay, this is a bit strange, but but still true. But then it's a little bit odd if I start saying that I did things that in fact other people did. So, and this is kind of what joint liability is doing, right? Like we're not just saying, oh, we all made a cake together. It's saying that, I cracked the eggs. We're saying, I'm held legally responsible for cracking the eggs somehow, even when someone else cracked the eggs. So I'm setting aside the question for now of whether or not this is actually what's going on in joint liability, although this is kind of stated as what's going on in at least some kind of prominent case on joint liability. But the argument that I really want to make is that even if this is what's going on in joint liability, this is not what's going on in accessory liability. Because first of all, accessory liability doesn't actually really require this concerted action. You can help or assist or encourage someone to do something without actually doing that thing, or even without having kind of a shared intention to arrive at a certain outcome. That's not something that's part of the liability analysis for all accessorial wrongs. So it doesn't seem like the reasons we would have for this legal fiction in joint liability necessarily apply in accessory liability anyway. And also, even if we could attribute the act of the primary wrongdoer to the accessory, that doesn't necessarily mean that that's enough to say that the accessory breached their duty, even in this fictional way. That the kind of features of the primary wrongdoer's act don't necessarily totally line up with the duties that an accessory has, especially when we have some kind of extra requirement of intention the primary wrongdoer doesn't have for their own primary liability. So just to kind of illustrate this a little bit more, I just want to talk about the wrong of dishonest assistance, which is also something that is going to come up a few times throughout this talk. So dishonest assistance is a wrong for inducing or assisting with a breach of fiduciary duty or a breach of trust. So a breach of duty, a breach of fiduciary duty, or breach of trust, you have someone who is acting on behalf of someone else. So trustees holding trust assets for beneficiary, fiduciary is exercising some kind of power on behalf of someone else. So think doctor-patient relationships, solicitor-client relationships, that kind of thing. So we can't really have attribution of action as really a justificatory step for accessory liability here, because accessories or dishonest assisters don't have fiduciary duties. So just saying, well, this accessory misappropriated trust funds or took money from this bank account to this bank account, that doesn't really tell us what's wrong with that. Just moving money from one bank account to another bank account isn't wrong unless it's a violation of a legal duty. Dishonest assister doesn't have the same fiduciary duties. That's not really a good route to say this person is legally responsible or did something legally wrongful. So probably not going to work for accessory liability. So what about our next option? Next option, we don't need to do any kind of weird mystical attribution of action. We just find some other reason for holding person Y legally responsible. It's a little bit unclear to me exactly what that reason could be in the private law context, not ruling out that this happens in other contexts. For example, outside of the law, we can think about kind of like moral taint. Just by association, we feel like there's something there's something wrong just by association with something, with someone who did something wrong. But I don't think that this also doesn't really seem like a really satisfactory way in the private law. I don't really see a lot of good reasons to do this in the context of a private lawsuit. So this kind of leaves the third option that I think is the most promising. So this is where we say, person Y does something. They're responsible for the consequences of their actions, and this is the way that we can hold them legally responsible. I think this is probably the most promising because we already do this in the private law. For example, we see this in quite a few negligence cases. This is a case that a lot of people will read in their first year torts classes. Home office and Dorset yacht. So this is a case where some youths who were youth offenders were on a camping trip on an island. Due to allegedly poor supervision, they escaped from the island and stole a yacht. Everyone kind of in the literature refers to these youths as the Borstal boys. So the Borstal boys, obviously, not that good at driving yachts, so damaged the yacht. So the plaintiff, also understandably, wasn't happy. Sued the home office for being negligent in their supervision of the youths. So this is a case. The court was only looking at whether there was a duty of care and held that there was, because the home office had a responsibility to kind of not create this unreasonable risk to the community posed by poor supervision. So this is a case where you're holding the home office responsible for damage caused by the Borstal boys' choice to steal this yacht and their conduct in damaging it. So but you might say, oh well, Allison, this is not a great example because it's a public authority. Maybe public authorities exercising these kind of public functions have special duties somehow. But we also see this in cases not involving public authorities. So here's another negligence case called Rankin's Garage, Supreme Court case. Very sad case. Two teenagers were drinking and doing drugs at one of their parents' houses, decided to go for a walk and try to break into cars to see if they could steal things, and ended up getting into Rankin's garage, commercial garage that was not secured, managed to find an unlocked car with the keys just inside. Fortunately, the teenagers decided to steal the car and go for a drive. Car crashed, and the teen who was the passenger suffered very severe injuries. So the case makes it up to the Supreme Court. And kind of controversially, the court held that Rankin's Garage was partially liable. They could be liable in negligence for not securing the garage. So this is another case where we're holding someone liable.
Liable to who?
Liable to the catastrophically injured boy.
Right, okay.
Yeah. So sorry.
The parents?
But both. Actually, that's a really good question here. Yeah. So yes, liable to the boy, but yes, family members can also sue for damages in these cases under a different statute. So yeah, not a crazy question at all. But yeah, in this case, and partially liable, the court apportioned liability, including partially to the teen's mother who was, not supervising these teens in the home drinking and doing drugs illegally. But anyway, the main point here is just that, this is another case of negligence where it kind of looks like we're holding someone liable for someone else's wrongful act. And so this has, I think, some things to recommend it. It kind of explains a connection between the accessory's conduct and the primary wrong. How are we getting from point A to point B in terms of the accessory doing something and holding them liable for this thing that looks like someone else did. But it doesn't really get us the whole way there because we still need an explanation for why we're holding the accessory kind of liable for this consequence in the first place. We don't generally just hold you liable anytime that your actions have some kind of bad consequence. We still need to have that breach of duty as the starting point. So I think that these scholars who are talking about attribution and accessory liability are, onto something, but aren't really answering the question they necessarily think they're answering. I also just want to kind of briefly, no, I don't want to go back. I also just want to briefly touch on maybe a question that I had kind of going through this. Do we have a causation problem? If we're talking about consequences, this is kind of saying that there's a causal relationship. Are we comfortable saying that one person has caused another person's actions? Basically, I think there might be, a philosophical problem with doing this, but the law actually seems to think that it's totally fine, at least in some cases. So sometimes the law will treat one person's actions as kind of an intervening event that kind of breaks this causal chain of analysis. But sometimes the law says, yeah, you can cause another person's action as long as it's a natural and probable consequence of your action. So maybe a metaphysical problem with the law, but that is the current state of our legal causation doctrines. So just to summarize this part, so I think where we've gotten to at this point is that the way that attribution works in accessory liability is probably this idea of consequence attribution. We're treating the primary wrong as a consequence of the accessory's wrong, rather than saying the accessory just did the primary wrong themselves. But this still doesn't really answer the question that I'm really interested in about, why we have accessory liability in the first place. So now I want to move on to kind of the second answer that's been posed in the literature as to why we have accessory liability. Some scholars have said, some variation of the argument that accessory liability exists because it protects a plaintiff's primary right. There's a duty, not to interfere with someone else's primary rights because it's good to protect them. So again, we're still talking about accessory wrongs being a breach of an accessory's own breach of duty. And so this answer doesn't, look that bad on the surface because, it's still holding the accessory liable for their own inducement or assistance. And, we also kind of see this with, dishonest assistance. So I'll talk a little bit more about the case in the context of dishonest assistance that kind of illustrates this point, where the court pretty explicitly adopts a view along these lines. So this is a Privy Council case called Royal Brunei and Tam. So an airline hired a travel agent to sell airline tickets for them, entered into a trust agreement that the travel agent would sell airline tickets and then hold the subsequent proceeds on trust for the airline. But don't trust all travel agents because this particular travel agent just didn't pay the airline. Also wasn't putting the trust funds in the right account. But anyway, so the airline brought an action against the sole director, the guy who is in charge and control of this travel agent company, who is clearly the one responsible for all these kind of sale proceed issues. And the court made a number of comments about dishonest assistance. I apologize for how texty this slide is, but this was the court's rationale for recognizing dishonest assistance. And what I really just want you to notice is the kind of language that they're using about how they're describing the duty. So there's the wrong of dishonest assistance is this deliberate intervention in the primary right, intentionally intruding on the trust relationship, and importantly, preventing the beneficiary from getting their entitlement that they're entitled to under that primary trust relationship. So this is describing the wrong of dishonest assistance as a duty of non-interference. So we think that accessorial wrongs are wrong because they're interfering in these primary relationships, which again, I think there's something that rings true about this. It is interference, inducing or assisting does look like interference in some way, but still seems like it's not really getting, to the heart of the question of why it's illegal or wrong. It's just describing the duty, rather than justifying it. So you might say, well, why can't we just justify the plaintiff's right the same way that we justify the plaintiff's primary right? If the plaintiff's primary right is, presumably justified for some reason, whether that's, a right against a fiduciary, right against a party who they've contracted with, why can't it just be the same? We see this again in Royal Grenade per Lord Nichols. We care about making sure beneficiaries get their entitlement. What's wrong with that? So this is, maybe going a bit more to the heart of debates about why we protect primary rights, which I'm going to talk about, kind of more in different sections of the talk. And so at this point, we're just kind of focusing on the first two. If we're saying that we're relying on an interest of the plaintiffs to justify both the primary and the accessorial right, it kind of puts us into this theory of private rights, where we think that it's about kind of protecting the right holder, the plaintiff, or alternatively kind of promoting some social goods. And another alternative is this kind of protection or functioning to create the equal negative freedom of the parties, which I'm going to talk about in the final section of the talk. But on this view that is also quite prevalent in the literature, we recognize this plaintiff's primary right because they protect some kind of interest of the plaintiff. For example, we might say we protect contractual rights because we want people to be able to rely on promises people make to them. So that can also justify rights against third parties. Another variation of this is, achieving desirable social conditions through enforcement of private rights. Like, we might want to protect parties' contracts because they, promote market efficiency or something like that. Another thing that we see a lot in the literature is some kind of combination of this. So, some prominent scholars in this area have taken kind of pluralist approaches, saying, oh, there's no reason to just choose one. And this is also seen in Royal Grenade. So we see, the court talking about, both deterrence and, potentially protecting the beneficiary if the, say in this case, if the, travel agency doesn't have a lot of money to pay a judgment. So, in this case, what we're really doing is, we still run into some problems with this though. So, the first problem with saying this and just saying, the plaintiff's interests, or, alternatively social goods or complete justification is it kind of fails to kind of give a lot of answers to these doctrinal questions, even, kind of setting aside, maybe some deeper theoretical debates. Why is that we have certain limitations on liability? Like, doesn't this seem like it could be, extremely expansive, way more expansive than any of us are comfortable with, or that the, law kind of currently reflects? Why don't we have, we have secondary liability? Why don't we have tertiary, quaternary liability, et cetera? Why do we have, the intention requirements? Why does the defendant have to intentionally try to induce a breach of contract? Why is, reasonable foreseeability not enough? Why is, why do we have the kind of legal rules that we currently have? And also, why is it that only some of the plaintiff's interests should be legally protected, but not others in this legal context? So this seems to open the door to an extremely broad range of accessory liability availability in the private law context. And kind of relatedly, why, how can we make this fit the positive law? I think, kind of a key part of these types of approaches to private law theory is that we do kind of want any theory that we have to, at least somewhat fit the kind of main features of the existing law, especially the ones that we kind of have general consensus that they're important. And we currently have, quite stringent limitations on liability. So how do we kind of make this kind of justification actually speak to the current positive law? And how does it actually help us in resolving conflicts? When say that there's a conflict between different interests of the plaintiff. There's also, this kind of problem that I've alluded to earlier when I was talking about equal freedom of the parties. We're also concerned about interfering too much in people's lives. If with the context of inducing breach of contract, is it too much if I, say, advertise? Is that inducing you to breach a contract? Or if I sell you something that could be used to commit some kind of wrong, if I sell, something that could be used as a weapon, or I sell computers that could be used to pirate videos or whatever. Are we concerned about imposing too much on third-party freedom? And it also just doesn't really answer the question of why that primary legal relationship, has any kind of implications for third parties. So to summarize this part, so again, I think we've hit on something helpful here. Accessorial wrongs are an interference with the plaintiff's primary right that captures something right about it. That is a way of describing inducement or resistance. But it's unclear exactly why the justification for the primary right wouldn't necessarily be the same as for the accessory. That connection doesn't necessarily have to hold. And we still are kind of at sea looking for a justification that really explains why third parties have to do anything in relation to this legal relationship. So this brings me to the third and what I think is the most promising option, but is also the least developed at this point. So this is the option that I am currently spending time exploring as to why we have accessory liability, and that's to preserve the equal freedom of the parties in the context of the legal system, our system of private law as a whole. So again, we're kind of looking again at why we protect private rights. And we're focusing on this preservation of equal negative freedom. So in this kind of conception, so this does rely on a theory of private law, grounded on why we have law in the first place, which is to ensure that everyone can have the freedom to pursue their own projects, be persons, without interference by other people. So I should have the freedom to pursue my own projects to the degree that it doesn't infringe on someone else's freedom. So in the state of nature, we have all of these projects, but in the civil condition, we are all coexisting with everyone else. So we need to have a way to manage that. And so that's where private law comes in. That's to protect each person's equal freedom. So one branch of this that I want to address first, that I ultimately reject, are these what I call kind of quasi-proprietary theories. So some people have kind of sought to understand primary rights as having some kind of proprietary aspect, especially in the inducing breach of contract context. So if we say that contractual rights are, in the most extreme version, either are property rights or have some kind of proprietary aspect, then this kind of looks like it answers the question, because whatever justification there are for property rights, that is the exact same justification for this. So this is kind of what this is a kind of sophisticated view of this is what Peter Benson argues. So contractual rights, they're not full property rights, but they have this kind of limited in rem dimension before the contract is actually performed. And that's how we can understand inducing breach of contract. Against the world. Oh, I'm sorry. Yeah. So there's this kind of distinction between in rem rights and in personam rights. So an in personam right is basically just a right against one particular person. So this is kind of examples of this are, when we have kind of that special relationship that I'm talking about, a relationship that you don't have with everyone. and in rem is the right against the world. So property rights we think of as in rem. So if I have, this is my phone, I have exclusive rights to this, and that's against everyone. Not only some people, but no one has a better right to my phone than I do. And so this is kind of what Peter Benson is arguing for with inducing breach of contract. So if we understand a contractual right as having some kind of quasi-proprietary dimension, then we can just say that inducing breach of contract is just basically like misappropriating that property right. If we understand violation of property rights as a misappropriation of something of value, then that's one way of understanding this. So Peter Benson's view, I don't want, I'm oversimplifying a little bit for this talk. I definitely, recommend going and reading his book to get a better sense of his theory. But he ultimately thinks that inducing breach of contract is either like a malicious wrong or a misappropriation of the contractual performance. And so basically there's a necessity of the defendant actually gaining something in either case. So I don't know that this really kind of gets us to where we want to go. Because I am skeptical of the contractual performance. It does kind of have this necessarily in a rem dimension or a proprietary dimension. If you and I have a contract for performance, that performance is pretty specific. If I agree to build you a house, on a particular plot of land at a particular in a particular time, which you definitely should not do. Definitely don't ask me to build a house for you. Then that's pretty specific. So that's not really the kind of thing that can be transferred. If I just go and build a house on some other plot of land, that just looks like a totally different thing. Our dramatic artiste going and singing at a different opera house instead of the first opera house doesn't really look like a transfer. It just looks like a totally different type of action. And that is even a necessary condition for the contract to exist in the first place. And kind of relatedly, I also just don't think that we can really understand an accessorial wrong as a misappropriation of value. In certain other legal doctrines, we talk about these transfers of value, it's kind of a monetary value, but that just doesn't even really enter into the equation when we're looking at accessory liability. We're never really asking in the analysis whether the accessory actually, gained something of monetary value or personal value or whatever. So this kind of brings us to taking a step back and looking at the legal system as a whole. So maybe we can look at the interconnectedness of legal norms as kind of a starting point for asking why we have these kind of secondary wrongs. Because maybe the primary wrong and this other duty have some kind of relationship when we look at the private law system as a whole. And maybe we have some kind of requirement that legal norms have to be consistent with each other in order for our legal system to make sense and function and to be the kind of public institution that we want to have. And so one example of this is Ernest Weinrib's theory. So Weinrib's theory is obviously very Kantian in nature. So that is kind of a starting point that I have, although I don't think you necessarily have to have a purely Kantian view of the law and public right in order to kind of have some kind of understanding of the systematicity of legal norms. So Weinrib's theory grounded in Kantian legal theory, and he argues that we can understand inducing breach of contract. He only talks about inducing breach of contract, but I'm kind of extrapolating to all accessorial wrongs. So his starting point is this notion of the public right. Once we have the notion of the public, we need to have kind of systematic consistency and institutions that have public authority for everyone to enjoy this equal freedom. And so from this, we can get to inducing breach of contract. So it's because everyone has this everyone needs to have this assurance that their rights are going to be respected. And if we allow people to induce or procure or interfere with their rights, this would kind of be a failing of the legal system. We can't have a system where people don't have an assurance that their rights are actually going to be secured. So if we are allowed to induce violations of the rights of others, this kind of just disregards the existence of that person's private right. And that is just kind of inconsistent with you being a member of the public. So this, I think, also has a lot of promise, but I still have quite a few remaining questions. It seems like maybe it could be perhaps defined with more precision. So, we're talking about kind of disregard for someone else's legal right, but, this also kind of has problems with establishing limitations for liability. So, we don't have liability for just attempting to induce a breach, even though that also kind of looks like disregard for someone's right. What exactly is the plaintiff's complaint against the defendant? Earlier I talked all about how the plaintiff needs to have, a particular complaint, the defendant breached their particular duty to them. So is there a way for us to kind of frame this in language that's consistent with that? And also kind of a bigger problem, we're talking about the accessories disregard, but this, really looks like looking at the accessories kind of mental state and their intention in a way that sits kind of uneasily with the way that we normally think about legal rights as being about some kind of action that we can evaluate regardless of the kind of motives or reasons that the person had for acting. So how do we kind of reconcile this tension between mental state and how we kind of generally expect legal rights to operate as being about action? So one option that I'm exploring right now is an analogy with Arthur Ripstein's conception of malicious wrongs. So malicious wrongs are rare but really interesting. So in these cases, you have an action that would otherwise not be unlawful. But because of the defendant's reasons for acting, intention becomes a legal wrong. So again, this looks like it sits really uneasily with how we normally want legal rights to, not look at someone's motives, but like look at what they actually do. So a case that also shows up a lot in first year law classes, and Arthur also relies on in his book in Private Wrongs, where he talks about this, is Hollywood, Silver Fox Farm, and Emmett. So this illustrates exactly, what a malicious wrong looks like. Okay, so we have a defendant who is wanting to build a housing development, but is really worried about the impact that his neighbor's sign is going to have on his housing development. His neighbor has this sign that, I guess the defendant found quite unsightly, that said Hollywood Silver Fox Farm. So, our defendant goes to his neighbor and says, can you please take down your ugly sign? His neighbor says, no, I like the sign. So the defendant decides, okay, well, I know how to get him to take the sign down. So the defendant gets his son to go shoot a gun near the property line, which, keep in mind, that is, at this point, totally, like, normally would be totally allowed. You're normally at this point allowed to shoot guns on your property. This is not nuisance. That's totally cool. But not in this case. Why is it that in this particular case, the court actually holds the defendant liable for nuisance? It's because the defendant was shooting the gun in order to scare the foxes of his neighbor. If there's one thing that you take away from this talk, it's that foxes are very skittish.
Even the silver variety.
So these foxes, if you make loud noises around foxes, they miscarry, they eat their young. It's a really bad situation. Obviously, this neighbor has a fox farm. So this shooting of the gun scared the foxes. And so that's why the neighbor brought an action against after this defendant, is because the defendant was shooting the gun just to scare the foxes. And so cases where there's someone is doing something just to kind of interfere with the projects of someone else is unlawful in Arthur Ripstein's account of these malicious wrongs. So why is it that you have one thing that is normally lawful that becomes unlawful when it's kind of maliciously done? Because in Arthur's view, which I find very compelling, the defendant is using this interference or frustration of the plaintiff's primary, of the plaintiff's lawful pursuit of their project kind of as a means. And this is just inconsistent with how our legal system is supposed to be securing equal freedom of everyone. We couldn't consistently allow everyone to be pursuing their own projects independently of one another if you could use the frustration of one person's project as the way that you're pursuing your project. So my question is, could we potentially draw an analogy here with accessory liability? Is it possible that something, somewhat similar is going on here? In this case, we would say accessorial wrongdoing is wrong because, what you're really doing is you're using the interference with the plaintiff's primary right as a means for your own project in some way. And so this would, have the benefit of kind of explaining why this, why accessory liability requires this intention and maybe refine exactly what this intention requirement should be. And it also allows the plaintiff to just kind of describe in kind of private law terms, why the accessory is wrong with them specifically. So the plaintiff's complaint is that you interfered with my primary right to pursue your own projects. So in this case, we have the starting point maybe for a theory, but there's still lots of remaining questions. One of them, obviously, is that it looks like there is a bit of a difference between malicious wrongs and accessory liability because, is it really inconsistent with the equal freedom of everyone when we already have a primary wrongdoer who chose to, breach their own legal duty? Is it really as much of a problem in the accessory liability cases in the malicious wrong case where we have this kind of middle actor? So there might be some points of tension with analogizing between these two, which I'm still working on. But that is kind of where I'm at with this, with exploring this potential option. So it looks like, there could be something to the idea that accessory liability is justified because it's kind of required by the purpose of the legal system of securing everyone's ability to kind of equally pursue their projects. And this interference with someone else's primary right would be kind of inconsistent with the kind of overall purpose of the legal system. And this also has, maybe a bit of a better fit with the existing case law that does have these limitations on liability. So before we conclude, I just want to kind of briefly summarize some of the things we've talked about. So we kind of started with some questions about accessory liability. So, exactly, how expansive should accessory liability be in private law? There's a lot of debate about that. How uniform should it be? Should it be available more or less? Like, why do we exactly have the amount that we have? What exactly is this weird intention requirement doing? Why do we have it? And what should it be? And also, relatedly, how much of this is about causation? Is this legal responsibility that's causal or not causal? What is the kind of basis for holding people legally responsible when they engage in accessorial wrongdoing? We also, I think, identified some of the conditions that we need for a successful theory of accessory liability in private law, whether we've actually gotten there today or not. I've argued that it should be consistent with corrective justice, this idea that the court's role is to correct an injustice between two parties where a defendant breaches the legal duty. It should also actually be helpful in explaining what exactly the breach of that legal duty is. And most importantly, it should be able to exist in legal terms why the duty exists in the first place. I've also tried to make some first steps towards developing maybe a little bit more of a refined theory, drawing on some theories of scholars here at the University of Toronto, looking at how can we understand this primary wrong. This accessorial wrong is a accessorial wrong. as causing the primary wrong as a consequence, and being understood as interfering with the relationship between the primary wrongdoer and the plaintiff, but also kind of situating the description of the wrong in that way within the legal system as a whole, and the purpose of the legal system as securing everyone's equal freedom. So with that, I want to thank you so much for listening to my talk. I'd also be completely remiss if I didn't thank my supervisor, Chris Essert, for all of his help, and for Arthur, who's given some helpful comments as well. So thank you again for listening.